just a few more people joining, so give it. All right, I will continue to add, but we can get started. Welcome, everyone. Good afternoon. I hope you're enjoying today's day. My name is Gina. I am the voice behind what you can see here. I am also your moderator for today. You are in room C, where we are hosting the workshop entitled IPV and Child Protection Mediation in ADR, Time to Take Another Look. If this is not the workshop you intended to be in, please go back to the main room and someone will help guide you to where you want to be. If at any point during this presentation you have some technology issues, again, go back into the main room and they will help you get back to here. I will turn it over to our presenters shortly. Just a couple of housekeeping things. Please mute your mic. And when we get to the end of today's presentation, there'll be some time to answer questions, or if you want to put them in the chat, you can. They will be addressed near the end of the presentation. And other than that, I will send it over to our wonderful presenters.
Welcome. As Gina has just said, we're going to talk about family violence and child protection ADR. So I'm going to turn it to Geoff, and maybe we'll just do introductions first. So Geoff, if you want to start off.
Sure. I'm a family lawyer practicing in Oakville, Ontario. I also do a large amount of mediation and arbitration. I'm a CP Med, and I'm on the OCL panel, and I argued the Ahluwalia case about the tort of family violence at the Ontario Court of Appeal, and I am representing the respondent in the application for leave to the Supreme Court of Canada. So I do a lot of talking about family violence at this stage in my career.
Thank you, Geoff. Or sorry, Jim.
Hi, I'm Jim Fitch, and I'm, among other things, a child protection mediator. My particular interests are in the impact of family violence on families that may be going through dispute resolution proceedings generally, family dispute resolution. And I'm glad to be here, and I appreciate your time.
And I'm Maggie Hall. I'm the director of the Mediation Center and its division, Mediation North, and also a child protection mediator. My little claim to fame is I'm the only child protection mediator in the province that never took the training, because I was one of the trainers at the inaugural trainings. Anyway, on that note, let's get started. So Geoff, if you want to lead us off.
Sure. So I want to start by just emphasizing the growing public and legal awareness of the critical nature of family violence or intimate partner violence. And the Ontario Court of Appeals decision in Ahluwalia is really the most prominent case about family violence in Ontario in a very long time. It was a case about whether or not there would be a novel tort of family violence. So whether you'd be able to just sue somebody for an umbrella tort of family violence, or whether or not you had to bring specific actions for assault or battery or other well-established torts. The Court of Appeal ultimately decided against the novel tort, but in the course of the decision made various comments about the role of intimate partner violence in our society, and actually begins the entire case with the quote that we have on the screen here at paragraph 1 of the decision, noting that family violence takes many forms, including physical violence, psychological abuse, financial abuse, and intimidation, and references the scary statistic that nearly half of women and a third of men have experienced intimate partner violence, and that rates are on the rise. Our legal system as a whole is taking significantly more notice of this. And I think that the manner in which the legal system is looking at this forces professionals involved in the ADR community to reconsider how we've historically looked at cases involving family violence. Obviously, my colleagues can speak about this much more, but historically, there's been an inclination to screen out anything involving family violence. And as we spread the definition of family violence to something significantly more than what it was understood to be 20 years ago, I think that we need to consider exactly how we're doing that. So Maggie, if you can go to the next slide. So the I thought the next slide was the definitions. Okay. There's two significant changes that have happened in family law legislation in recent memory. And all of our family law legislation was amended in 2021. And a significant emphasis was placed on family violence. Family violence was introduced as a criteria for the best interest of the children. And given this very broad definition in Section 2 of the Act, such that it means any conduct, whether or not the conduct constitutes a criminal offense by a family member towards another family member that is violent or threatening, or that constitutes a pattern of coercive controlling behavior, or that cause any other family member to fear for their safety or that of another person. That is a far broader understanding of family violence than we had in the past. When I started practicing in family law, that is not how we considered family violence. And I think that this is a definition that was reached at with significant discussion within the government that reflects the modern understanding of what family violence is. And it has a profound impact on families. But what it forces us to do then is to reconsider how we've treated family violence in the past, because this includes behaviors that may not have been considered family violence previously. The other thing that the legislation does is it includes a significant emphasis on ADR. And if you can go back to the previous slide, there is the section of the Divorce Act that mandates matters to go to ADR. So Section 7.3 of the Divorce Act provides that to the extent it's appropriate to do so, the parties shall try to resolve the matters through family dispute resolution, which is what the Divorce Act calls ADR. So it is a mandatory provision that parties shall do it. Obviously, we're talking about CPMED here, so I'm not going to get into the case law around that. But courts have been forcing parties to attend mediation, even where one party doesn't want to. A court will force them to go to an intake session at least. And so, it's important for us all to note that right now there are two general movements in family law in this province. The first is to address family violence, and the second is to promote ADR. And they need to be seen to be going forward hand in hand. And we can't, in my view, sit back and just say that, well, they're totally separate. We can't consider the two of them together. Obviously, the situation in child protection is somewhat different. SIFSA doesn't include family violence as a criteria for best interest of the child in Section 74 sub 3. But there are a number of ways that family violence can be seen as a ground for finding that a child is in need of protection. The federal legislation respecting First Nations, Inuit, and Métis children for child protection, which thankfully was upheld just recently as being constitutional, does reference family violence with respect to the best interests of the child. The province has simply not followed suit with respect to SIFSA. And the legislation hasn't been amended since 2017. So SIFSA came into place 4 years before the other legislation did with the definition of family violence. Hopefully at some point in the future, the role of family violence in determining best interests will be expanded in SIFSA. There are also different provisions with respect to ADR and SIFSA, as I'm sure we're all aware. On the next slide, I believe it refers to the language, and again, it's very different. Instead of providing that ADR shall take place, it provides that a society shall consider whether ADR would assist in resolving any issue. So the threshold to force a matter to ADR in SIFSA is significantly lower. But the reality that I think that all of the ADR professionals need to be aware of and need to understand from the litigation world is that our courts right now in large portions of the province are wildly overwhelmed. The delay in getting court time, even in child protection matters where we have firm timelines, is extreme. In Central West, where I practice, it is a regular thing to see cases going well beyond the timelines under SIFSA because we simply don't have the judges to hear the matters. And the way that we as ADR professionals can help to address this backlog is to take on more CP Med files, to send more things to family group conference or any other method of ADR, and to reconsider what kind of files are appropriate for ADR in child protection context. My personal perspective is that in the past, we've been taking a far too narrow approach as to what can be handled through ADR. And I'm sure my colleagues will talk about that more. So Jim, can I pass it over to you?
Thanks, Geoff. So what I'm going to talk about generally is the latest academic literature around family violence and parenting and family dispute resolution. Something happened in the last 24 hours, though, that I want to talk about. Last year, Maggie and I gave a presentation to this conference, and I started my portion here's by saying that one of the things I was grateful about, a positive development, is it looked like severe acts of physical and sexual intimate partner violence in particular had started to decline from the tsunami, which is what I described it, of early COVID days. In the last 24 hours, we've had our third family annihilation, femicide, suicide in the last year in Ontario. So while maybe overall the stats still are down a little bit from the peak, we need to be incredibly cautious, and obviously our hearts go out to the victims of that and other offenses. So we are very, very lucky, changing the gear rapidly. We're very, very lucky to be working in the immediate aftermath of a great special issue of AFCC's family court review. And that's a special on family violence and parenting. We're also very lucky, and everyone from here is like Dr. Saini of the University of Toronto was one of the guest editors. I wanted to do a better job of copying the hypernym of family violence, really, really useful graphic. I was unable to do that accurately. If anyone after would like a copy of that or of the article that it's from, I'm very happy to assist. A quick note about so-called parental alienation. For the moment, they left it out of the hypernym. It acknowledged that in serious cases, alienating behaviors can be emotional or psychological abuse of a child. So more in tune with what I had to begin my session here with, family violence is a major public health crisis. I don't like the word epidemic personally because I think that is something that is in health law reserved typically for disease. That being said, it's an absolutely broad crisis. Saying this, broadly present in North American families, regardless of age, economic status, race, sex, gender, sexual orientation, religion, ethnicity, creed, and culture. There may be some groups of elevated risk of family violence. There's controversy even around that. I think it just happens everywhere. One thing that we do know for sure is that there are some communities that chronically underreport family violence. Black persons are one, and male heterosexual persons are another. There's also apparently persons of extremely high economic status tend to underreport. Do we know why these groups underreport? We really don't. There are certainly suggestions that I think are often heavily influenced by stereotype. Maybe the stereotypes are partially correct and partially incorrect, I don't know, but we do know that there are underreporters. So there's an iceberg of family violence, and we're only seeing the tip, which is horrid. Okay. Let's talk about femicide. I have typically in the past referred to a homicide caused by intimate partner violence as IPV homicide. We know, however, that it is overwhelmingly committed against persons that call themselves female. So I think it's safe and appropriate to use the word femicide as a synonym. It's what I'm going to do. Okay. Femicide is my professional nightmare. I will say I haven't lost anyone yet and not planning on starting, but there are certainly risks to that. Now, arguably, except for coercive control violence, strangulation and choking, whether that's physical, sexual, or both, is the incident of IPV most directly related to femicide, particularly femicide by male causers, who are a very large majority of the persons who cause femicide. But as I said here, that we can't safely predict it. Lesbian, bisexual, and transgender women are victims of femicide. And in fact, in an article in the new Family Court Review special issue that I talked about, says there is certainly a discrete possibility that bisexual and transgendered women may in fact be at higher risk of femicide than heterosexual ones. Okay, exposure to intimate partner violence is child abuse. We'd refer back to, as Geoff did very well, the definition in Section 2 of family violence. And I take a quote, and in the case of a child, the direct or indirect exposure to such conduct. Tiny bit of editorial language here that says these are wounds that stack, but they are. Children are incredibly resilient when it comes to family transition. They're not resilient at all, though, about family violence and exposure to family conflict in general. So does abusing your partner or the parent, your co-parent of your child, is that child abuse? Yes, it absolutely is. It is, and it needs to be recognized as such. Okay, another topic, talk about alienating behaviors. The best definition of alienating behaviors are we call it perhaps parental alienation, are behaviors which seek to impact negatively upon a relationship between a child and her co-parent, and that may constitute emotional or psychological child abuse, which is family violence. Interestingly, though, those same behaviors may be protective acts in response to family violence caused by that co-parent. And most challengingly, they may be both. I'm not going to talk further about parental alienation. It's an issue of significant controversy. Do I personally believe it exists? Yeah, probably. I also think it's a lot less common than people say. I'll leave it there as far as this. And now I should like to pass the baton on to Maggie Hall. Maggie, if you're ready to take over, but also follow along with your slides if you wish.
Thank you, Jim. So what does all this mean for us as practitioners? We have a responsibility to ensure that our processes are safe and equitable. not just for the parents, but for the plans that are developed, meet the safety test and best interest of the children involved. So how do we do this? Historically, we have ensured safety and equitability by screening out for domestic violence. Sort of at one point in my history, if there was an incident, it was screened out. That was the general word. If there was domestic violence, we didn't mediate. And I think, when you listen to what Geoff is having to say, and we know the stats are so prevalent, I think that we need to take another look at this. And that's really what I wanted to do today. So I'd like to suggest that we go from a process of systematically screening out to a matter of the assumption that we're going to proceed with the recognition that there may be some cases that are not applicable or not appropriate, and those we will address on a one-by-one. But the screening out should be a last resort, and I'm going to explain what I mean by all that in a minute. So Jim, going to change screens. So I think that the first thing, and anyone who's done training with me before knows I've been kind of hitting this for a while. I think that we as mediators need to recognize our power, and by recognizing that power, we are held responsible for how we wield that power. And when we screen out cases, we are essentially telling, being the boss. We are saying, nope, you've consented to mediation or you've consented to ADR, but we are trumping your consent and we are disallowing you from proceeding. And that's a form of power. And I think we have to take that a little bit more responsibly than we have been, of hiding behind this systematic approach. And I think that we need to differentiate the forms of domestic violence that we're seeing. So let's talk a little bit about that. So Jim, do you want to switch the forms, the slide? So really, we first started to talk about differentiation back in 2007. It was the real move from a one-size-fits-all approach to family violence. And so the Wellspread Conference was a gathering of international, including a number of well-known Canadians, into this conference in Wingspread, and which they really came together to talk about this whole idea of domestic violence, to try to find common language and to sort of find a way to move forward in terms of a profession. And out of that, if switching slides again, Joan Kelly and Michael Johnston, shouldn't be a T in that. Michael Johnson.
Sorry.
So they came out with sort of defining 4 distinct forms of intimate partner violence. And there's been controversy around some of these definitions, but I think certain things have clearly become mainstream, including our definition of including coercive control in the definition of the Divorce Act. So when I look at the 4 types of intimate partner violence that Kelly and Johnson prescribed, was coercive control violence. And this is the first time that we sort of recognize this violence, which is not illegal. It's not a criminal code issue. You can't be charged with, criminal code violation of coercive control in this country. There is one main country that has, but I think there's a bit of a mess there about it. It's generally seen as the most dangerous, and it's the pattern of behavior designed to create unequal power. So when we think of the Duluth circle of violence and the various variations of that, that was really about coercive controlling violence. How do we one person in a systematic pattern of behavior has taken to control the other person. And it's typically coercive control, violent. Perpetrators are men. And so that's sort of part of the dynamic that has historically been in place. Violent resistance violence is typically the violent response from victims of coercive control. And so if we set those two aside, then they talked about situational couple violence, where these are just couples that have difficulty in conflict management and communication. Those behaviors can be exemplified or exasperated when alcohol or other impairments are in place, or in specific high stress situations. It's an equal gender opportunity. We know these people will be out socially, and you'll see a couple that make everybody really uncomfortable in the conflict that they have going on between them. But then the next time you see them, it doesn't seem to happen. It's not based on fear. It's not based on control or power. It's on bad behavior, or perhaps poor behavior. Separation-induced violence is, again, we see in both genders, and this is acts of IPV committed in response to a traumatic circumstances, separation, allegations of child abuse or sexual abuse, or affidavits in general. I think they're trauma arising items. These are people that you'll hear comments that we never had it before. It came out of the blue. It was completely unexpected. It can happen several times, but it doesn't typically a pattern of long-term behavior. It varies from mild to severe, but it's probably the behaviors that, and we've all come across these, where clearly it's not fear and intimidation, although people may be concerned or cautious. Ironically, I listened to Vicky and Michael Siney at their trust workshop this morning, and really a breakdown of the trust in the relationship. And that can be in part of our challenges in terms of ADR, but breakdown of that, the trust in that relationship because of something that was a reaction to this traumatic event. Okay, next one. So although we haven't seen broad spread adoption of these differentiations, we have seen certainly this new concept of coercive control, and it's not really new, but is now being sort of new in terms of it being part of our statutory changes. And certainly a lot of articles that you read now, they sort of talk about, well, it depends on the form of IPV. So whether or not we have an agreement on what the forms are, we certainly have recognition in the literature that how we behave as ADR specialists or interventions really needs to look at what the form of IPV is. And so I'm going to argue that as we proceed in ADR with families where IPV, part of our initial preparation or intake process needs to be really focused on what forms of IPV are we seeing, and then to look at what we can do about that. But beyond just that, I think we also have to hear the voice of the survivors. We talk about the voice of the children all the time, and yet we, systematically screen out matters where we have domestic violence, even Jim, recent domestic violence, and we'll talk about that later. And I think hearing the voice of the survivor is really important. And this is really, there's research that in the current journal that Jim referenced that talks about how we often see a huge change once our Jim likes to use the word sufferers of IPV, of coercive control IPV, are no longer under the control of their abusers. So I think we have to hear the voice of the survivor. Where are they? What do they want? I've heard, women say to me, I want to do this. I want to sort of face the perpetrator. And that doesn't necessarily mean in person. It doesn't necessarily mean even in direct contact, but that they want to be heard. We also have to be aware that what the alternatives are. And the alternative is often court, and nothing disempowers people more than our court process. So sort of recognizing what the alternatives are. We need to be aware of those timelines. So what stages in recovery? What are the court orders? What could bar and impede mediation? So there's a whole bunch of factors that we need to look at. And we also have to look at our tool chest. What could we do to help to make this a process that would work? And that might be, is this a better thing to do online as opposed to in person? So we're not bringing people physically in the same space at all, even in separate rooms in the same space. Is it appropriate for shuttle? Is it appropriate for involving lawyers or support people? And I'll put a little caveat around support people that they're, I'm going to call them professional support people as opposed to a parent who may or may not be the right kind of support for someone. Staggered arrivals or departures, even just having a safe word so that somebody in the context of a mediation or an ADR can simply say breakout room or do the old Carol Burnett thing. And immediately my move is going to be to drop them in a breakout room, no conversation required. And then I will follow them in to find out what's going on. And to recognize that we're always screening. It's an ongoing process. And when we talk specifically about coercive control, I think that we have to be even more aware on some deeper levels to know that also often in coercive control relationship, the capacity of in most cases, the mom, as a parent has been diminished. So the matter might be in the child protection system because mom hasn't been able to engage, or that mom's not providing adequate care. And yet the father may be presenting as very well put together and as the outward face and the parent that took the kids to their activities and dealt with the schools and dealt with the doctors. And mom's credibility might even be a question at some level just because of the nature of the dynamic. So, and sort of being very cautious that we are not sort of reinforcing that dynamic in the ADR that we're doing. And the argument can become, since we as ADR specialists do go to a great extent to be trained and up to date in terms of the theory around IPV, probably more so than judges and lawyers. And so to recognize that switching them to that process may not be, in fact, the best process for them. And we have to also remember that post-litigation, members of families experiencing CVV tend to continue to have poor outcomes. So again, what we've been doing isn't necessarily working. We know incidents of abuse tend to often increase following separation, and often our families in child protection are also families going through separation. So if you would just switch that over. Okay. So what does this mean? So we know that most children are going to continue to have a relationship with both parents at some level. There may be conditions, but typically children continue to have a relationship with both parents. We know in child protection especially that we work with a lot of good people who have done bad things or made poor decisions, which doesn't inherently make them bad people. It just means that they need to buy in and create a meaningful change in order for things to progress the way they want them to. And whether this is history with addictions or history in any other form, it seems to be that we accept that people can change, except maybe where we're identifying IPV. And so I challenge us that I think that if we can get buy-in to the plan, if we can get buy-in that this is an issue and people can take action to bring about meaningful change, that we have long-term positive implications in terms of compliance and in terms of repeating the bad behavior on a go-forward basis. Like addiction, like any other area, is there going to be 100%? Absolutely not. But I think that we have to at least acknowledge that the potential is there and refocus our energies. And again, I go back to that workshop today with Vicki and Michael, and sort of talk about the importance of developing a trusting relationship with the professional, which I'm not sure the court system is the best engagement of developing relationships, and using those trusting relationships in an incremental building of trust between the ADR specialist and the family, and including our potential perpetrators, and also in rebuilding trust in certainly some forms of IPV between the clients, so that we do have a better positive long-term outcome as we move forward. Jim, do you want to just move that forward? Oh, and I guess I'm just repeating a couple of things that we need to obviously still stay relevant to best interest, and but to recognize that ADR may be safer than court proceedings. Geoff's off now, but he was telling me about a court in GTA, criminal court, that there's a timed turnstile, and that's their way of making sure that perpetrators and victims leave within time, so that somebody can get in their car and depart, or get on the bus and depart before they're followed. So I guess I'm not, and I'm just quoting him on that, that if we could be looking at screening out not as our last resort, and there are cases, and before people start getting mad at me, there are cases that we won't proceed when we have fear and intimidation that we can't address in our tool chest at this point. Then obviously those aren't going to proceed. But I'm going to argue that a lot of the cases that we previously screened out, because there was a number of assault charges, or because there were I think if we are defining them as separation instigated, I think there's ways in many of those cases for us to deal with them, and that we need to be looking at things on a case by case as opposed to a systemic approach. And so I'm going to leave it there, because I know we have some time, and we want to make sure that we have time for questions.
Can I add something
Yes.
just to what you said? Sorry, I dropped off briefly and fell off, lost my pin. I want to reiterate, what Maggie's saying here. As somebody who litigates cases involving allegations of family violence, both representing the perpetrators and representing children involved in child protection cases where there's allegations of family violence. I think we really need to be cognizant of how these cases work in court, because it is not my opinion that they work well. And I think that you would struggle to find a large number of family lawyers who litigate a lot, who think our legal system or our litigation system is working well right now. There's a lot of delay, and we operate in a box. There's only certain ways that things work in court, and there's not enough flexibility to offer the same kind of protections that we can create in the ADR process to ensure that survivors are not just physically safe, but also emotionally safe as they go through the process. An inherently adversarial process, child protection litigation is adversarial, especially in situations where there's allegations of family violence, is very difficult for survivors to navigate. They are re-traumatized as they swear affidavits or see affidavits over and over again if they have to testify. These are traumatizing events for survivors. Beyond any of the questions of physical safety, these are difficult things to go through. And you're also going to be forced to be in the same room, potentially, as the perpetrator. And the recourse of the court at the end of the day is to make sure that there's police officers available to protect you. But we can go so much further to protect people emotionally in a process where we completely control the design of what's happening.
So Geoff, let me ask you a question. What kinds of families, or what families would you not refer to ADR where there's IPV recognized?
I think I probably, would be willing to go further than you are, Maggie. And that's because, I see firsthand how bad this goes. I go to court and advocate for the 7-year-old child in a child protection case where the reason they're in CP is, or the reason why they're in court is domestic violence between mom and dad. And my 7-year-old client is telling me, oh, I hide in the closet when daddy hits mommy. And then he says to me, I really want to see my dad. I want to spend half the time with my dad. And, dad denies it's happening. And, mom is saying it's a pattern of coercive control. And the physical violence is one element of a much bigger problem. And I see how horrible that is for everybody involved in the litigation. I think that when we control the process, we can almost always do something better than what happens in court, or we can at least try. Because if we're doing this virtually, if we're doing it with breakout rooms, we have the ability to create something where I can't see how it would be less safe than going to court. And I have seen so many instances firsthand where people are getting in fist fights at court. Court is not a place where there's no conflict. The fact that police officers are there doesn't force people to be reasonable. And let's be realistic here. Perpetrators of family violence are generally not inherently reasonable people. They are breaking social norms, and they know they are. We can't expect them to act reasonably. And I think that, in my view, in the interest of everyone involved in this, and I think, what Maggie talked about getting buy-in from perpetrators is critical as well. It is worth at least trying a process of ADR, whether it's a family group conference, where you can get the whole family to talk about the situation, or it's, CP mediation. I think that we can always look at something, and it's in my view, it's always worth a shot, because I don't think litigation is serving these people well.
Okay. So Jim, I have a question for you. Where do we go from here, in your opinion?
Can I stick in a quick editorial note about virtual proceedings?
Jim, I wouldn't expect less of you.
or more, clearly. I have a minor disagreement with Geoff around the use of virtual as a safety tool. And obviously you and I talked about this at this conference last year, Maggie. Just because something is remote doesn't automatically make it less safe, but it doesn't automatically make it more safe either. And a lot of people, unfortunately, I think in our profession have gone to the assumption that it makes things more safe. And I really want to reiterate my challenge to that. I don't think it's less or more. You don't know, as I say this, I always assume that everybody's got a gun to their head on my screens because they might. Is it likely? Of course not. Of course not. But it's more than zero, and anything more than zero is infinity more than zero. So there, so that's it. So we got to be careful about virtual processes too.
But Jim, I could control that to somewhat by having mom attend at her lawyer's office, and for them to be participating together with the support of her lawyer in person. And I'm pretty sure that the lawyer doesn't have a gun to her head.
Strong agree, and I do it all the time. But we just always have to be cognizant that we are not wizards, right? We are mechanics, engineers, intelligent people. We are not wizards. We are not doing magic. So so there's that. In terms of what I think is coming next or should come next. I think everybody here knows that I am opposed to mandatory mediation in any family matter, but I think there could be a world where mandatory screening for the appropriateness of family dispute resolution comes in and probably should. I'd like to see it. I think it's what is next. I worry that we may go down the hill towards mandatory mediation or mandatory ADR, which again, I'm opposed to. But if we had mandatory screening and a very standardized form that doesn't include hint, hint, it's all her fault or it's all his fault in it, right? If we had a standard form that says these people, in my opinion, as a professional ADR expert, so to speak, practitioner, sorry. As an ADR practitioner, I believe they have satisfied the mandatory screening or mandatory intake component. Just check a box, sign your name, leave it there. So there's no room for commentary, because something that will definitely happen is if there were mandatory mediation and we screen somebody out, the judges, courts, lawyers, parties will make assumptions that may be correct. They may not be correct, but they're going to be the same assumptions made every time. And I don't think that's good for us.
If I can just answer that quickly, Maggie, I expect that at some point in the near future, SIFSA will be amended to more closely mirror the language that exists in the Divorce Act. So the obligation to send things to ADR will become more stringent, I would imagine. The language that's in the Divorce Act currently is not mandatory mediation. It's you shall use an ADR process where appropriate, rather than the current language in SIFSA shall consider. So I think that would be one thing. And then adding more references to family violence in SIFSA when referring to best interests, I think is also something that is likely in the offering in the relatively near future. But I think that, as we all need to be aware that as our legal system continues to get overwhelmed, the number of judges is not growing sufficiently, the population is, more and more pressure is put on all of us who work outside of courts to help alleviate the stress that's on court. Because every matter that can be resolved through an ADR process means there's more attention to be paid in court to those that can't. It is a huge assistance to the legal system as a whole for all of us to resolve these matters rather for them than them be litigated.
Okay. I'd like to open it up to the group. Do we have any questions? Maybe there's one in the dots. I don't think there's anything in the chat yet.
Maggie, I do see one here from Raquel. It says, I wear both FGC coordinator hat and that of an OCL clinician completing assessments. I feel that litigious lawyers perpetuate the divisiveness and prevent resolution. 5 years ago, 50% of assessments resulted in resolution, but since that time, no cases resolved. I think that the matters that do not resolve in mediation and proceed to OCL are the highest conflict cases. It's a different climate now. So more of a comment to what we're talking about.
So I heard a couple of things. One, that they don't think lawyers are part of the solution, but just that we're dealing with more high conflict. I think we all agree that child protection work has become, a lot of our cases involve high conflict families. I think we can all accept that as just part of that recognition when the changes were made, that exposure to high family conflict was a protection concern, and we saw that the move from family court to child protection court of a large number of these high conflict families. In terms of the lawyers, I'll be the first. I involve lawyers a lot in my mediations, and as soon as you hear who the lawyers are, you kind of know where this is going. I don't disagree with that question. I think but that's part of education, right? That's part of us, is when we're intaking our lawyers and preparing them, is sort of having more realistic conversation with them in terms of what their role in this process is and what we're needing from them in terms of helping to help this family. Paula. Oh, you're muted though.
Maggie, one of the things I think we don't talk enough about is every mediator is not created the same, right? We have such very varied backgrounds. So when it comes to dealing with very high conflict, power and control, abusive, dynamics, I think sometimes it should be more send the file to a mediator who's very comfortable and competent with dealing with those issues. Because I think some people aren't. They're not comfortable with it. They're not good at controlling those dynamics, and that's my only point. I think often we're such a broad group as mediators, and I think sometimes we don't distinguish between each other.
Yeah, and again, I mean, I could speak to the CP Meds who signed the same agreement, undertaking with OAFM, that you know your own competency. So as mediators, we shouldn't be accepting files that are outside of our competency. So I think that's but again, if you're referring, then make a request when you're making a referral for a mediator with specific expertise in working with high conflict families. Mm-hmm. We do it with openness. We do it in a whole number of ranges.
We do.
Why can't it be with high conflict families as well?
I think we probably do informally more so, but I think there's a lot of people that are not comfortable with it.
Mm-hmm.
Paula, may I add something to that?
Yes.
I think one of the things that happens, to get back to what Maggie said about mediator power, is we've been trained in some ways, at least early in our careers, as though we should pretend that we don't have any, right? We're neutral, right? I prefer the word independent a lot, because the only way to be truly neutral is to be completely paralyzed, and paralysis is not going to help these families at all. It's going to hurt them 9 times out of 10. So assuming that we acknowledge our power in these formal situations, then we can balance our own power, and if necessary, and if my insurer's on the line, if necessary, utilize it in a way that will be effectual for a family, instead of pretending that it doesn't exist, and that's something happens a lot.
But I think the point Paula made is critical. Like, just because a mediation isn't appropriate for me, or a file isn't appropriate for me to mediate, doesn't mean it's not appropriate to mediate.
Right.
And like the ADR professionals need to be cognizant of the different options, right? Because family group conferencing is very different from CP Med. And like the The professionals
Mm.
conducting the ADR themselves need to know about the different options and who their colleagues are in the area.
Mhm.
Before you screen something out, consider what the other options are, from your
Yeah.
professional colleagues to different models of ADR.
Yeah.
And, you know, the CAS professionals who are making the referral to ADR also need to be aware of the different people available in the area, because you
Mhm.
may have mediators who have a stronger personality or a more compassionate personality, or whatever the situation may be, that will be helpful for that particular file. And I think that, you know, a big message here is, don't paint with broad strokes. You know, when it comes to child protection, mediation, and family violence, and just mediation and family violence in particular, it's very specific. And we need to look at each individual file separately and think very carefully, is
Mhm.
there a way this can be done that is better than in court?
Yeah.
And my belief is that in most cases there would be.
Mhm. And I think, you know, these are transformative processes usually. I mean, I think for those of us that are quite interventionist in our approach. You know, I'm not saying if you have a sociopath in the room, you're gonna have a lot of transformation. But I do strongly believe that sometimes people just don't have tools in their toolbox. And sometimes just helping them with communication and interrupting the pattern and helping them do things differently in the process, they often leave better than they came in.
For sure.
So I guess that's how I would compare to court as well. You're not very transformed when you leave the courtroom. If anything, you're more hostile, you're more angry, right? Bitter.
Yeah.
Sorry,
I've
not
done
to-
litigation for approaching 20 years. I've never seen anybody walk out of court and say, that was a great process, I'd like to do it again. Or I like my spouse a lot more after that process. That was great.
No,
I
it's
think
terrible.
we're gonna be able to communicate better. And I think the transformative nature of ADR is critical. You know, we can heal rather than just calling balls and strikes, which is, you know, what the role of the court is.
This is obviously a great discussion and a great topic, and I thank Maggie, Jim, and Geoff for presenting it. I hate to be the one to always bring a close to this, but we are at the 2:15 mark, and I know this is a great topic. There were some comments in the chat. I know Vicky posted a comment just to share that we should all, as practitioners, be careful in the language we use. High conflict families are not necessarily IPV families. The terms
Right.
are often interchangeable, and obviously the circumstances and risk factors are very different, which is, I agree.
Absolutely.
And on that note, I think there's another session that's going to come in. So I do want to thank Maggie, Jim, and Geoff for this wonderful presentation. And I want to thank everyone on behalf of PAC for joining our workshop session. I do know there's another one in this room. If that's the one you intend to be in, you can stay in it, or you can loop back to the main room and then join the one that you want to for the rest of the afternoon.
Thank you, everyone. Thank you.
Thanks, everyone.
Thank you, everyone.